or something that we'll typically put in our client's estate plan, in their will, or even in their trust, is something called a no contest clause. And basically what that means is, if I'm leaving you something and you try to dispute the will, you try to dispute the trust, and you lose, whatever I was going to give you basically goes away, and now you get nothing. So here's how it might work in practice. Let's say you've got 3 kids and you've got $5 million, and you want to leave the bulk of it to 2 of them, but the third you don't really want to disinherit completely, but maybe they've just, they've been very challenging, they've stolen from you, drugs, alcohol, whatever the case may be. You don't want to completely leave them out. You want to leave them something, but you don't want to leave them a third of the $5 million. So in your will or in your trust, you say you want that child to get $500,000. You also put a no contest clause in there that says, if you challenge this will, if you challenge this trust and you lose, whatever I was going to give you goes away. So if that child challenges it and they say they want a third for whatever reason, whatever argument they come up with, and they lose, they don't just get 500,000, they get nothing now. So that 500,000 that you were going to leave them goes away. Now, if they win and it's found that the will was invalid for whatever reason, they might be entitled to a third, but we're going to assume that's not the case. Really, you're creating this provision for somebody who you think is just going to challenge the will. Now, one important thing is they actually have to be entitled to something. So it just can't be your neighbor who wants to challenge the will and you didn't even name them in the will to begin with, right? They wouldn't have any what we call legal standing to actually be able to even really challenge it. They have to have some sort of interest. Generally, they have to have been named as a beneficiary. So you don't do that clause for people you're worried about, long distance cousins who aren't named anyways. They would get thrown out of court anyways because they don't have any right to your estate. You do this really for somebody who you want to leave them something, but you're concerned that they might not be happy with it or they might try to challenge it. So I typically, there's no harm, no foul really in putting these in almost any will or almost any trust. It makes sense for most times. So if you've got that heir, if you've got that child, if you've got that beneficiary, and you don't have your plan, I would bring this up with your planning attorney. If you do already have your plan in place, just check that it has a no contest clause. It's a great thing to have in there.